Yes.
My Lord, my Lady, continuing my submission on the construction of the regulations, can I invite you, please, to turn to Bundle of Authorities 1, tab 2, page 40. Bundle of Authorities 1, tab 2, page 40, Regulation 14.
Can you just remind me, I got this, you're covered by the original regulation.
My Lord, yes.
But is there any suggestion they've changed in the regulations?
My Lord, I think the parties are agreed that it's the 2015 regulations are consolidating regulations, and I'm very briefly going to take you to the 2015 regulations to show.
One of the points which might be made, maybe is not, is we have this report, which you were shown briefly before lunch in 2015 of the committee, which seems to sort of summarise the case law at that point and draw the attention to some of the problems. But that is not, I mean, they could have taken the opportunity to amend the regulations, but no one did. So one could say, well, that means it's to some extent an endorsement of the then law. But I don't think that's a point that anyone's actually made.
My Lord, no, I don't think they have, because they're consolidating regulations. I'm not sure that point is.
What are they said? I mean, you say they are. Is that what they say?
I think that's the agreed position.
Okay, what if it's
I beg.
No, not quite. It's the explanatory note makes clear that it's a remaking and consolidation. And as you'll recall earlier, I referred to one of the specific points of the 15 regulations being to make the rules clearer. So it wasn't simply a consolidation of existing regulations. There was a return to the wording for purposes of trying to make it clearer. But we're accepted that they're substantively the same as the earlier regulations.
Well, we may need to
Make them clearer. That was an ambition not quite fulfilled.
Yeah, I mean, there's a lot of law about the effect of consolidation acts. I'm not very familiar. Maybe Lady Arden. I mean, my law commission experience doesn't sort of tell me what you do with consolidation regulations. But
My Lord, I'm concerned with the 99 regulations.
yes, I understand.
So
we've obviously got to look at this broadly.
Yes.
What we say, hopefully, will be of assistance to the 2015 regulations as well. So.
My Lord, yes, and it is what we say, in effect, is they are consolidating regulations, but it's fair to say that it was a bit like the draftsman having been sent home with a bad copy, saying, do a fair copy, this isn't quite good enough.
But as far as the points we're dealing with, they're broad, I mean, they don't...
Substantively, we say there's no difference, certainly in salaried hours, and that's why also one of the reasons I'm going to take you very briefly to the 2015 regs.
Okay, well, we'll see where we get. Thank you.
My Lord, starting at Regulation 14 at page 40, the hourly rate for a worker is simply arrived at by taking the total pay referred to in paragraph 1, and that's calculated in accordance with Regulations 30 to 37, and in this case that may include the accommodation offset, which I'll take you to, and then it's divided by the number of hours as ascertained by subparagraph 3, and that is under Regulations 20 to 29. For a salaried hours worker, we go forward to page 43, Regulation 21. Regulation 21.1 provides in this regulation the basic hours, and you'll remember before lunch I talked about the basic hours as being the basket of annual hours, means the basic number of hours in a year in respect of which a worker is entitled under his contract to his annual salary, as ascertained. And I highlight the word ascertained, and it's the second time the regulations have used it. They used it in Regulation 4.2a, and they use it here again. As ascertained in accordance with his contract on the first day of the pay reference period in question. A pay reference period can be a month, up to a month, but in this case, Mr. Shannon, everyone agrees it's a week. So the regulations direct one to look at the basic number of annual hours that one can ascertain on the first day of the week, as it were, in which he's being paid. And then that is used for the calculation, that number of hours. Under Regulation 2, the annual number of hours is divided, whereas here, paragraph 2a, the annual number of hours is divided by 52 to get to a week's pay. And that is the calculation for salaried hours work. There are only 3 exceptions to the application of that calculation. the first exception, and you can see that that is set out in paragraph 2 of Regulation 21 before your Lordships and your Ladyship. The three exceptions are firstly paragraph 3, which actually encompasses two exceptions, and secondly Regulation 22, and thirdly Regulation 23. That is the express meaning of the regulations. Paragraph 3 is an exception, that is, the number of hours may be reduced where a worker is sick. Paragraph 4 deems industrial action to fit within paragraph 3. So that's why it's only 3 exceptions, although the paragraph 3 exception also, or the paragraph 4 exception comes within the paragraph 3 exception. So that's the first exception. The second exception is Regulation 22. Regulation 22 across the page is where one has to determine the hours of salaried hours work where the basic hours have been exceeded. And that means someone's been paid for a package of hours. And just, I'm not going to take it further. Someone's paid for a package of hours. Let's say 1,200 hours, and they're paid monthly. By September, they have worked 1,200 hours. So they've exceeded, or they're about to exceed, the number of annual hours they've been paid for, but they've only been paid for under their monthly salary for 9 months of work, for 900 hours of work. So to see whether or not, to examine whether or not someone has exceeded their hours, for the purposes of Regulation 22, paragraph 1, one uses paragraph 3. So where in any calculation year the total of the hours referred to in paragraph 3 exceeds the basic hours, this regulation, and not Regulation 21, applies for the purposes of determining the salaried hours worked by a worker in the pay reference period. And if one goes over the page to paragraph 3, one sees the first mention of Regulation 16. And paragraph 3 is the trigger provision. So this is what a salaried hours worker uses if, which wasn't the case in Shannon, if the salaried hours worker is saying, I've exceeded my number of annual hours. And what happens under paragraph 3 is the sums at A, B, and C are taken into account. But importantly for our purposes, the first function, the first time we see Regulation 16 engaged in salaried hours work, is time required to be treated. Pausing there briefly, time required to be treated. It is only a deeming provision here. It is never a decision-making provision. It is never, are you working or are you not working? It is not the test of whether you're working, it's whether or not you can deem additional time. Time required to be treated as working hours by Regulation 16. It is not a gateway to the decision as to what's working hours, it's a deeming provision. And that's time required to be treated under Regulation 16 to the extent that such time consists of hours in respect of which the worker had no entitlement under his contract to his annual salary or any other payment. So that's where Regulation 16 has its first function. That is, it comes into play for the first time as the trigger provision. It is then brought into play the second time to assess the actual number of working hours where a salaried hours worker says that they have exceeded their hours. And there, if I can take your Lordships, please, and your Ladyship, to paragraph 6 of Regulation 22. One then adds 2 figures to the salaried hours worker. The number of hours that result from applying Regulation 21.2, and you'll remember in my example of the person who's worked 1,200 hours already by September, their October pay should obviously include the salaried hours which they've already worked for, and that's what Regulation 6A applies. And then, in addition to that sum, is the sum at paragraph 6B. And there you refer back to paragraph 4. And my lords and my lady, I apologise for the Stygian nature of these regulations.
You're not personally responsible, I don't think, Mr. Glynn.
Is this your new point, or is this?
This is what my then friends call the new ground.
Oh, I see. It would have been helpful to learn that that's what we're dealing with.
I beg your pardon, my lord.
So I hadn't appreciated. But this is your new point.
You say it wasn't raised in the Employment Tribunal. You say it wasn't raised in the Employment Appeal Tribunal. Was it raised in the Court of Appeal?
Yes, it was, but it wasn't put in the skeleton, and it was raised for the first time in oral submissions in the Court of Appeal by me.
And they declined to deal with it.
And they declined to deal with it, my lord, yes. But I will, my lord, I'm so sorry, and that's my fault that I didn't
But
make...
it's just that I thought we were going to be asked whether you would have permission to deal with the new point, but maybe...
My lord, I'm certainly going to deal with that, but before I can...
You've got to explain what it is before we can say what it is.
You're ahead of me.
We're going to hear it the better.
You're ahead of me. Before I can ask you to deal with it, I have to explain what it is.
Yes.
It's really my point.
Yes, it's just knowing that I've got to get my head around something which hasn't been covered so helpfully by Lord Justice Underhill.
I'm
Right.
grateful. And then in paragraph 4, one sees at paragraph 4b, so this is the actual working hours. One uses the actual working hours at A, 4a, the number of hours in the pay reference period that would have fallen to be taken into account of 3a, and that's actual working hours. And then you add that, again, time required to be treated as working hours by Regulation 16 to the extent that such time consists of hours in respect of which the worker is not entitled to under his contract. So again, Regulation 16 has a second function in salaried hours work, that is, it deems further hours work where the hours have been exceeded. And, my lords, that in short is the only purpose of Regulation 16 in salaried hours work. It is not, and it is never used as a distinguishing factor between what's work and what's not work. And one can see that.
But I mean, your point on this case is going to be what?
That-
You know, I'm sorry. I take a little more time than
the basket, the ascertainable number of hours identified by the tribunal is 10 to 7, 10 o'clock at night till 7 o'clock in the morning. He was paid either £50 or £90, and that shows the rate of pay, which was below the national minimum wage.
And you say that should all have been treated within his basic hours.
Yes.
Didn't occur to anyone at this point.
No, and it never has. And maybe when one sits down and reads the regulations in such complexity, any salaried hours work has never dealt with them in that way, because we say they have never been properly understood. Or, I beg your pardon, I'm not claiming anything because I only came to it late in terms of understanding it. But we say that no court or Employment Appeal Tribunal or Court of Appeal has, apart from obviously this Court of Appeal, has had the opportunity to consider the true meaning of the regulations.
The trouble is, this was an oral agreement between two friends. It's not surprising. It was.
Well, that may be.
No, I mean, too bad, but there we are.
But my lord, can I turn you back then, please, to, or can I turn forward, please, to divider 3?
Just before you do that, where is the contract in accordance with which the annual salary was to be ascertained?
I'm going to take your ladyship to that. It's in paragraph 10 of the Employment Tribunal decision.
Fine.
But, my lady, may I just take this legal point before I go to the employment? I'm not ducking the point at all. If I then go, please, to page 51, tab 4. And I'm taking the 2000 version of the regulations, and we say it's just simply because they are perhaps the first reworking of the regulations. It's not said that there's any difference between the first version and the 99 regulation.
So tab 4 is the 2015 version.
I mean, tab 3.
Tab 3.
Tab 3, I'm so sorry, my lord. Tab 3, page 51, under Regulation 7, this is what what replaced the old Regulation 16 with 16.1 and 16.1a. Two things to note about this regulation. Internally, Regulation 16 is self-disciplined, by which I mean to say it is only operative if one looks at the fourth line for the purpose of and to the extent mentioned in Regulations 22.3d and 22.4b.
Sorry, where are you reading from, please?
The fourth line of the little one under Regulation 7. So subject to paragraph 1a, and then 4 lines below that,
Yes.
for the purpose of and to the extent mentioned in Regulation 22.3d and 4b.
Yes, I see.
So the regulations themselves between 21, 22 obviously only bring in Regulation 16 into account from their point of view, but also Regulation 16 disciplines itself not to operate any wider in a salaried hours case.
So do we need to go back and remind ourselves of 22.3d and 4b?
22.3d is the triggering provision I took your lordship and your ladyship earlier for extra hours, and 22.4d 22.4b is the calculation of hours when you have triggered working more than your annual basis of hours.
I see.
The second point, my lords, is that if one looks at Regulation 1 there, it is subject to paragraph 1a. So 1 is the dominant clause, but 1a limits further the exception in paragraph 1. So just as a matter of statutory construction, 1a is limited to the effects of paragraph 1. So 1a itself is also limited to 22.3d and 4b. And that is consistent, is it not, with, we say, with regulations 20, 21 and 22. Turning to the question posed by Milady Arden, where was the contract found? Can I ask you please to pick up the Shannon core bundle and turn to Appendix Part 1, and it should still be covered by page 709. This still should be covered by MS numbers. So the core bundle of Shannon, Appendix Part 1, page 709. Part 1, page 7, Appendix Part 1, page 709, paragraph 10. So at paragraph 10, the agreement and its obligations, its contractual obligations, are set out here.
Sorry, I'm afraid I haven't got that. 709,
709, paragraph 10 of the Shannon core bundle, my lord.
709 has the notice of appeal in my electronic.
The other bundle.
Is it the right
Are you in Shannon?
Oh, no,
That's-
it should be in Shannon.
That's the Tomlinson-Blake
Yes,
core
of course
bundle,
it
the
is.
core
Sorry.
volume.
I'm sorry about that. 709, right? Off we go.
The agreement between the claimant and Mr. Sparshot was oral and was never put in writing. Its terms were the claimant would be employed, as he described it, as an on-call night care assistant. He was required to be in the studio from 10 p.m. until 7 a.m. That was, and that is, a contractual, an obvious contractual obligation, the requirement for him to be in the studio. He was permitted to sleep during those hours. He was required to respond to any request for assistance by the night care worker who would be on duty in the home. The second contractual obligation, the requirement to respond. So the first contractual obligation was to be in the studio, his flat, from 10 p.m. to 7 a.m. And the second was the contractual requirement to respond from the studio, obviously, between 10 p.m. and 7 a.m. if requested to do so. In return, the contractual obligations of Mr. Sparshot and, in time, Mr. and Mrs. Rampersad, in return, the claimant was given free accommodation in the studio with all amenities, fuel, water, free of charge, and he would receive a weekly payment of £50 a week, which rose at about the time of the national minimum wage to £90 a week.
And how much would it have been if he'd been, on your argument, if he'd been on national minimum wage?
My lord, effectively that is 63 hours. I haven't got that calculation. My junior will be doing it now, and I'll return to it on 99 terms, my lord. I will return to it. I'm sorry I don't have it immediately available. Now one turns then to page 722, please. 722. Paragraph 86. Now, the National Minimum Wage Regulations, 1999, define various types of work. Regulation 3 and 4 define time work and salaried hours work. The parties agreed that the claimant's contract was for salaried work. We agree. And then we say what is the crucial finding, He was paid the same amount each week, that is the £50, or as became in time £90, for an ascertainable number of hours each year. And the only number of hours mentioned in the judgment are 10 p.m. to 7 a.m. And that is also concordant with the obligation, the contractual obligation, the ascertainable number of hours that I've mentioned under salaried hours. Where that is the case, we say respectfully, on simply the correct construction of salaried hours work, the conclusion to which a court should be driven under the legal definition of salaried hours work is simply to take the basket of hours, that's 7 hours, in this case, I beg your pardon, 9 hours a night. You could determine what that was on the first day of the pay reference period. Mr. Sparshott, they agreed he would work 9 hours every night, and that gives you your annual set of hours, which in that case, 9 times 365 gives you 3,285 hours. And then you look at it, you divide that number of hours by 52, because it's weekly paid, to get the number of hours weekly paid, which is about 63.17 hours. And that's the calculation one has to do on a proper understanding of Regulation 21, we say.
So give me that figure again.
All the figures together are 3,285 hours, which is 365 days of doing, or 365 nights. One divides that by 52 to get 63.17. For that, the claimant was paid some £50 and or £90. If one puts that calculation into the national minimum wage as it was in the very beginning, which was £3.60, one gets to a figure for my Lord Carnworth of £227 and 41 pence. £227.41.
Per week. Per week.
Per week, yes, my Lord.
Instead of the 50 to 90 pounds.
Instead of the 50 to 90 pounds. There may be a can I just say, there may be a deduction of that sum as a result of the provision of of the provision of a flat, which at that stage was £19.95. So there's allowed to be an offset, and I'll come to that in a moment. But the amount of that is 227, but I'll come and show you that one deducts.
So the effect of the new regulation, you say, was that this great family, this formal arrangement should be going until 1993, when 50 to 90 pounds suddenly becomes an obligation to pay 227 pounds.
And rightly so, because what Parliament intended.
No, I'm not saying
Yes.
what's right or wrong.
Yes,
I just
I'm sorry, I was
understand the logic of it.
Yes.
And it didn't occur to anyone to argue this point until 20 years later.
Yes. My Lord, can I take you very briefly to the 2015 regulations, which don't affect our case, but they remove from any doubt what we say is our correct explanation. If one goes, please, to tab 4 of the Authorities 1 bundle and go to page 67. Tab 4, page 67. One finds here Regulation 21. Regulation 21 is a clearer enunciation of Regulation 4 in the 99 regulations. I don't need to spend time of it because I'm looking purely at how Regulation 16 works. Then Regulation 22 of the 2015 regs is the old Regulation 21. And paragraph 5 is the old Regulation 21.1. The basic hours are to be ascertained in accordance with the worker's contract on the first day of the pay reference period in question, unless paragraphs 6 or 7 apply. And that's subject to the 2 exceptions in 6 or 7. Again, paragraph 6, that is, if the hours of salaried hours work in a pay reference period are to be ascertained in accordance with regulations 24 to 28, if additional hours in excess of the annual hours are worked under paragraph 6A, and if the employee is not entitled to be paid more. And then paragraph 7 is for the termination provisions. One then before one turns through, it's important to say that in salaried hours work, unlike Regulation 32 and time work, Regulation 16 finds no independent basis in these regulations. It doesn't stand independently. What's happened now is the effect of Regulation 16 is expressly folded in to cases that fall within paragraph 6. That is where an allegation is made that more than the annual basis of hours is worked. And can I take you over the page, please, to Regulation 27?
This is the mechanism for that.
Sorry?
Is Regulation 27 the mechanism?
It is the mechanism, and it is the mechanism, my lord, yes, precisely.
Right.
And the mechanism here is, instead of Regulation 16 as being freestanding as we saw it, the words of Regulation 16 are now pasted into 27(1)(b) for the home exception. And then paragraph 2, making itself again, just as Regulation 16(1)(a) did, subject to the home exception under B, where the sleep-in exception is given. Now, I don't trespass over to the time work argument, but it does show there, in terms of the draftsman, that what Parliament is intending to do is make Regulation 16 purely a deeming provision for additional work. It's not defining what is or is not work. And then the payment provisions, so that 27 is the trigger provision, my lord. The payment provisions under 28(1)(d) and 28(4)(c). This is where again, the number of hours treated as worked in 21D, in 28(1)(d), and the number of hours treated as work in 28(4)(c). So in both times, they're extra deeming provisions.
Sorry, the first one of those is which one again?
I beg your pardon, my lord?
You've drawn our attention to
28(1)(d).
28(1)(d). That's the one, thank you.
And then 28(4)(c).
Yeah, I had that one. Thank you very much.
And, my lords, we say that we should be allowed, permission should be given to raise this new ground because, and it may be that this is just a point without substance, so I take it quickly. When permission was applied, we set out in our permission application it was a new ground. And that is at, just for your reference, that is at page 545, paragraph 23. The respondent objected at page 557, these are core bundle references, the respondent objected at 557, para 15 and 16, and said it was a new ground, and in any event, if permission to appeal was allowed, permission should only be given on the first 4 grounds, and this is ground 5. So we say this court, to an extent, has given permission. I move on seeing my...
Well, no, I'm afraid it doesn't immediately spring to mind that this point was live, and we didn't address it specifically.
My lord, that's why I don't press it, and why I take it without reference. I beg your pardon. My lord, just what we say simply is this, is that there's a pressing public interest.
Yeah, I mean, I'm sure we would have said, well, let's deal with it at the hearing.
Absolutely.
I don't think we'd have knocked it.
And my lord, I'm not, certainly not before this court am I suggesting anything that permission has been necessarily given. I just simply refer to that. We say that we accept what Ms Stone and Mr Parkins say, that it's an exceptional course to allow a new ground to be raised. We accept that. But we say there's a pressing public interest because no case ever has properly analysed what salaried hours work is. And if that were to continue to be the case after this court, which is dealing with difficult and sometimes difficult to interpret legislation, then it would risk leading courts below into error. And the 99 regulations are still effective for those who may or may not have redress, because because national minimum wage proceedings can be taken in the civil courts with a limitation of 6 years. So it is important that people understand their rights. There's a pressing public interest that those who have salaried hours understand properly how they can or cannot enforce their national minimum wage. And we say that means, that is the first ingredient of the exceptional test. But we go on beyond that, and if I can ask you please to take up the core volume.
Presumably there's a limitation period of 6 years.
Yes. We go beyond that, and we also show that the Court of Appeal has been inconsistent in the terms of how it's dealt with this matter. And can I take you please to the core volume, again the appendix part 1, page 672. At page 672, at paragraph 42, the Court of Appeal agreed with the analysis that where regulations 21 of the regulations apply, or 22, a worker treated in any pay reference period as having done his or her basic hours to the calculation of which the availability provisions are irrelevant. So the court accepted that they were irrelevant. But if one turns forward, please, to page 690, paragraph 98, the court went on to say the case was argued in the ET and EAT on the basis that the crucial question was whether during periods in question the claimant was actually working or available for work, and the case on that question was expressly considered. The ET found he was only available for work so that Regulation 16.1 and 1A applied. Just going down a few lines, whichever applies, the crucial question is whether the claimant was actually working or only available for work. With respect, that's not the crucial question under the regulations, because Regulation 16 is irrelevant.
Well, I just wanted to ask you about that, because he still has to show that what the contract relates to is work, and that he is a worker, doesn't he? And the only hours we're talking about are the hours, the contentious hours overnight. So he still has to be a worker. Now, as I understand it, before the tribunal, it was common ground he was a worker, is that right?
It's common ground he was a worker.
For the purposes of the Minimum Wage Act?
Yes.
So that was a concession, but there's no actual finding.
My lady, I beg your pardon, my lady, I'll have a look at whether that was agreed, or I don't think that was ever in dispute, perhaps.
Thank you.
But it was it ever necessary to consider what his work consisted of?
Under Regulation 21, yes. My Lord Kitchen said that work is dealt with in the context of the regulations. Yeah. And if one adopts that, under Regulation 21, of course it is, and Regulation 21 provides the code as to what work is. And that work under page 43, the basic hours means the basic number of hours in a year in respect of which a worker is entitled under his contract to his annual salary as ascertained in accordance with his contract. And our submission, my Lord, is simple.
Yeah, you say it's simple, that's what he was paid to do and that was his work.
Because that's the contractual obligation, is to remain in the premises between those hours and to respond. That is the only way in which one can analyse the word requirement.
Right.
So, my Lords, we say that the Court of Appeal has firstly found that Regulation 16 would be irrelevant, but then has gone on inconsistently with that finding to consider that the first question one should ask under paragraph 98 is whether or not one was actually working or only available to ask under Regulation 16. And the Court of Appeal simply has failed properly to exercise its discretion or give reasons as to why this point shouldn't be determined, is what we say. The final point on the new grounds is we say no new facts are necessary. There is nothing further that needs to be found. One has the contractual requirement to be in the flat between the hours. One has the contractual requirement to respond. That is it. This is a salaried hours case. My learned friends say, well, had that been the case, we wouldn't have agreed it, and we would have argued time work, or we would have argued unmeasured work. And I say, well, you could have argued it, but you'd have been wrong because you have an ascertainable number of hours with the same salary being paid. So my learned friends can say that that's what they would have done, but if one actually looks at the result of what they would have done, it would have had no effect.
Well, they can still argue, can't they?
And argue it very, very well they do. My lord, I'm just simply seeking to meet their argument. But, my lord, say I'm wrong about that. Say that they're right and this is an unmeasured work case. And can I just quickly take you to the unmeasured work test? And that is found behind tab 2 of the Authorities 1, page 47. And, my lord, the classification of hours is rather like putting a marble into a game of Kerplunk. Is if it's salaried hours, it goes no further. If it's time work, it goes no further. If it's output, it goes no further. And then the sort of the dustbin diagnosis, as it were, is unmeasured work. Is how it works. This is not, and I know that sometimes when people speak to me about a case I did last week, I can't recall the facts. That may be my. But this is not a case such as Lady Arden dealt with in the Court of Appeal on a daily average agreement. There you have, under Regulation 28, the concept of daily average agreements. I'm not going to deal with that. I don't have time, because all I say is, if I am wrong that this is a salaried hours work case, and I say I am not, but if I am wrong, and my learned friends are right that this is an unmeasured work case, it would fall to be dealt with under Regulation 27. Unless the condition in Regulation 28.1 is satisfied, the unmeasured work worked by a worker in a pay reference period shall be the total number of hours spent by him during the pay reference period in carrying out the contractual duties required of him under his contract to do such work. If that's the test, then we pass it in precisely the same way as I will show you we pass working time. Because what were the contractual duties required of him? To remain in his flat between 10 p.m. and 7 a.m., to respond from his flat between 10 p.m. and 7 a.m. There is no difference if you apply the Regulation 27 test to this case. Can I then go on to the other points taken against me by, taken very skillfully and properly against me by my learned friends for Mr. and Mrs. Rampersad, is the Low Pay Commission, firstly. We say the Low Pay Commission goes as far as it goes, but it can't, we say, contradict the express meaning of the regulations. It's as simple as that. And more than that, the Low Pay Commission was not directed towards someone like Mr. Shannon, who was paid one sum for all his duties. Low Pay Commission was you pay an allowance and then you pay national minimum wage. There's no such agreement, no such provisions, no such element for Mr. Shannon. And where you have, as you have here, the express words of Regulation 21 and the self-limiting words of Regulation 16, the Low Pay Commission must cede to the express words of the regulations. Secondly, my lords, it said, my lords, my lady, I beg your pardon, it said that, secondly, on behalf of the respondents, it said that the provision of living accommodation takes this matter out of salaried hours work. We say that isn't the case because Regulation 9, and if I can take you please to page 39, Regulation 9 provides that, for the purpose of regulation, the following shall not be treated as payments by the employer to the worker, other than, if you look at paragraph A, any benefit in kind other than living accommodation. My lords, I hope we handed, my lords, my lady, I hope we handed up, and the reason this was handed up was because the authorities bundle The final authorities bundle was finalised before we had seen the respondent's case. Quite properly, nothing wrong in that. The respondents came on board very late. So Regulation 30, the total, and here's page 1 of the National Minimum Wage Regulations 1999, the total of remuneration in the pay reference period shall be calculated by adding together, and we're in subpara D, where the employer has provided the worker with living accommodation during the pay reference period, but in respect of that provision is neither entitled to make any deduction from the wage of the worker nor to receive any payment from him, the amount determined in accordance with Regulation 36. And if one turns to page 3 of this mini bundle, Regulation 36.1 is the lower of two calculations. And the first thing I'd like to show you is at subpara A, 36.1a, the amount resulting from multiplying the hours of work done in the pay reference period, determined in accordance with Regulations 20 to 29, that of course include 21 to 23 of salaried hours work. So it's expressed by the regulations in any event that that salaried hours workers are included for the purposes of the accommodation offset. In fact, this case falls into subpara B because that's the lower of the two sums, and what's required is an offset of £2.85 times 7, which is £19.95, which I referred to earlier. So, my lords, we say there's nothing in that point taken by the respondents. The next point taken by the respondents, this is a salaried hours contract, but should be treated as a 0 hours contract, and therefore you're into the Regulation 22 if you exceed the number of hours. We say that's not the finding of the tribunal. The ascertainable number of hours is clear, 10 till 7. In any event, the idea of having a salaried hours, 0 hours contract is a nonsense. It simply doesn't work. My lord, on those bases, we say that should determine the appeal. But if it doesn't, we move on to our second submission. And here we are all square. We stand all square with Mr. Jones. The court should determine whether the claimant is working first, and only then, if not working, move to Regulation 15 or 16, which are deeming provisions. My lords, my lady, this is legislation designed to protect the socially excluded. Intellectually, what Parliament does and what lawyers are used to doing is starting with the most protected status first. And we analyse whether or not one fits within the most protected status first, and then one works out, if all the ingredients are there, one stops the analysis. Or one works out in a concentric circle. And you can see that type of approach with worker classification, worker status cases, where you have an employee, a worker, or an independent contractor. You don't start at worker, you start at the most protected status, which is employee, and you analyse that first. There may be factors common between worker and employee, and indeed there may be a factor that makes someone a worker and excludes them from an employee. But what one risks doing if you go straight to the worker test, if you risk going to the least protected status, or not the most protected status first, you risk not taking into account the full amount of facts to determine whether or not that protected status exists. In the National Minimum Wage Regulations and the Act, the protected status is working within the context of the regulations, as my Lord Kitchen points out. Now, we consider and we respectfully say that what courts should do is they should examine firstly whether someone is working before going on to consider other classifications. And one does that because it may be, this court may find it far-fetched, but if it were the case, for instance, that one simply starts at, is one permitted to sleep on the job, then one might think of some Svengali somewhere who says, what I will do in order to keep my workers at a workplace ready to work whenever I want them, whatever happens, I'll just build dormitories. Just build a row of dormitories, they have to be there. I can just pay them an allowance, there's no guidance on that, but that's all I do. Expectation, yeah, I expect them to sleep, but I just want to call them. I want to have them there when I want to have them there. If one starts at the point of availability first and one looks at that, one risks building an avoidance or an evasion culture. But more than that, much more likely than that, if one doesn't start at the most protected status first, one doesn't have a proper analysis of that, then one risks falling into error by not taking into account the factors that actually make work.
Can you have a hybrid situation where somebody is for part of the time working and for the other part of the time available for work? I mean, take the example of Scott Bridge, for instance, that factual pattern, somebody performs some duties for some hours, for the rest of the time he simply has to be available.
Yes, one could. Take the school caretaker who works 9 till 5. Caretaker works 9 to 5. He has premises at the school, and he has to be there working between 9 o'clock and 5 o'clock. But his employers say, you also need to be ready to respond to something that happens between the off hours and the weekend. But you don't have to be there. And that would be a crucial distinguishing factor, we say. And I'll go on and show you the example of Ray. And what we say, this consideration of the most protected status, that is what the settled law since 2002 has been. That's what courts do. It's the Court of Appeal, the Court of Session, 3 presidents of the Employment Appeals Tribunal. Of course, none of them bind you, but there's a settled body of law that they consider what's working and what's not working. And in the good sense of employment tribunals, just like the word reasonable care and negligence is open to any number of factual findings, that's the job of the tribunals, to make those factual findings on proper bases. And the settled authorities that my learned friend took you to, BNA and Scott Bridge, which I don't repeat at all, settle that approach. And what the Court of Appeal in Mencap is it risks, we say, the settled approach and reverses the settled approach. It professes not to, but it does. If I can take you, please, to the core volume, page 686, paragraph 80, page 686.
It's the Court of Appeal judgment, is it?
Sorry, core volume,
yes.
part 1,
Yeah.
appendix part 1, 686.
What is it? Court of Appeal?
Court of Appeal. I'm so sorry, did I...
Some of us are working, some of us are reading the Court of Appeal judgment in Tomlinson-Blake because we don't want to read it in 2 different places. So can you give us paragraph?
Tomlinson-Blake, 580, paragraph 88.
Perfect, thank you.
At paragraph 88, as I hope is clear, my reasoning does not undermine the point of principle first established in the British Nursing Association decision, namely that the at-home and sleep-in exceptions only apply in cases where the case falls into the available for work rather than actual work category. So the Court of Appeal says it's not upsetting the apple cart in that respect. But if one goes to page in the Tomlinson-Blake bundle, page 566, in the Shannon bundle, page 672,
Sorry, what are we, we're in the Court of Appeal still?
the Court of Appeal, paragraph...
It's easy to just refer us to the paragraphs of the Court of Appeal.
Paragraph 43.
Yeah.
My Lord, I beg your pardon. I turn to consider how those provisions apply in a sleep-in case. If we're concerned only with the terms of the sleep-in exception, it is of course obvious that they are caught by it. They are sleeping by arrangement at their place of work. Logically, of course, that's not the first step, since the sleep-in exception only applies in availability cases and not in cases where the worker is actually working. It's strictly necessary to ask first into which of these 2 categories a worker who is sleeping in falls. Now, we say that's actually a reversal of the BNA approach, because rather than considering work first, and then considering whether the availability provisions apply, you arrive at a crossroads, or rather a fork in the road, and at the same time as you're making your decision whether you go left or right, you're looking at the availability provisions or the work provisions. And that may lead, then, down the slippery slope which we get to next in the Court of Appeal decision. However, that is, for practical purposes, an unnecessarily elaborate approach. The self-evident intention of the relevant provisions is to deal comprehensively with the position of sleep-in workers. So, in fact, you don't even need to consider work. You just see, does it fall within sleep-in, and you go down that road. So one is finding a complete reversal of BNA, in spite, we say respectfully, of the Court of Appeal, them saying it isn't. The fact that that case is dealt with as part of the availability provisions necessarily means that the draftsman regarded them as being available for work rather than actually working. That is hardly surprising. It would not be a natural use of language in a context which distinguishes between actually working and being available for work to describe someone as working when they are positively expected to sleep throughout all or most of the relevant period. And here we have then a new non-statutory test, we say, of the Court of Appeal, the positive expectation of sleep at paragraph 43. And if you go forward to paragraph 57, and if I can take the last sentence of paragraph 57 after the semicolon, but it does not establish that that will be so, and this is where he says he has no problem with the BNA decision, but it does not establish that that will be so in a case of the kind which we are concerned in these appeals, where the essence of the arrangement is that the worker is expected to sleep. So we say what the Court of Appeal is at risk of doing is creating a new non-statutory test of expectation of sleep to decide whether or not someone's working. And we emphatically reject that and say what a court has to do is consider the question of working first. And this decision of the Court of Appeal is an effective reversal of BNA. The learned friends for the respondents accept, obviously, that their submission is Scottbridge is wrong, so they accept, in my respectful submission, that that would end up reversing Scottbridge. But it's a reversal of BNA, because if in BNA you arrived at the fork in the road, and you said, is this person able to sleep and expected to sleep? Well, under the BNA facts which my learned friend took you through, between 11:30 and 5:30 a.m., indeed the tribunal found that, although the Court of Appeal disagreed, between the times of 11:30 a.m. and 5:30 a.m., they were bothered very little. So of course they'd be expected to sleep. So the Court of Appeal, with its expectation of sleep argument and its decision that one considers the fork in the road working or available for work at the same time, brings about a complete reversal in the law.
But in BNA, were there any sleeping facilities provided?
Milady, they were at home.
Well, so they were outside the exception we're concerned with?
Milady, yes, and if that was the case, so is Mr. Shannon, of course, because he's responding from his flat.
It wasn't treated that way, was it, by the Employment Tribunal?
No.
That point was put to one side.
The Employment Tribunal confusingly said all the period is working, and then, as my learned friend said, but this period was sleep, with which conclusion the Court of Appeal disagreed, but it wasn't before them, there was no appeal on that point, and therefore they couldn't interfere.
But these words, by the provision of sleeping facilities, are new and may lead to a different approach to the subset.
They may do, but my submission is it's the expectation of sleep question that's wrong. My Lord Cope, may I ask, I am going to overrun, if I may, subject to the court's permission, may I eat up into 5 minutes of my reply time by going up to 5 minutes past 3?
Yes.
I'm grateful. My final submission, so that's my second submission, is the Court of Appeal has got the wrong test. At the same time, one should always consider work first. My final submission gives the bright line clarity, perhaps, that the court may have been pressing Mr. Jones for, and we say does exist under the law. We say that presence, allied to the requirement to respond, allied to the regulatory obligation, give rise to a conclusion that Mr. Shannon was working. Firstly, the requirement to remain in one place. One sees this, and I've already taken the tribunal to this at paragraph 10, one sees this at BNA, where the worker is required to remain at home to answer the telephone. One sees this in Scottbridge. He was throughout in attendance as a night watchman and required at any time to answer the telephone or deal with alarms. And one sees this also, and if I may take you briefly to the decision of the Employment Appeal Tribunal, simply because it elucidates what was the learning of the sets of authorities and shows we say, a proper and appropriate way with which to deal with this question, is at Whittleston in Authorities 2, tab 22. Authorities 2, tab 22, page 285. And if I can take your lordships to paragraph 5, page 287. And the fourth line, what was required of the worker was to undertake shifts from 11 p.m. to 7 a.m., which were termed sleepovers. This was to provide potential physical care for 3 young adults who suffered from Down syndrome. She was provided with a camp bed, and the judge found with bedding, which she could use to sleep overnight in the living room of the house occupied by the 3 young adults. As it happens, there was no evidence that whilst doing that, which she regularly did she ever woke from her sleep in order to provide any specific care. And the analysis which Mr. Justice Langstaff carried out over the page, at page 289, at paragraph 15, the Regulation 15.1 point came up, and he determined that one determines whether one's doing work first, and if one's doing work, then Regulation 15 isn't necessary. But then 5 lines down, second, that work is not to be equated to any particular level of activity, and I adopt my learned friend's submissions on those. The saying, "they also serve who only stand and wait," is true, but it does not necessarily assist in knowing whether the standing and waiting is work or whether it is not. And we agree. It is not my submission that the mere necessity to be present is work. And then Mr. Justice Langstaff went on and showed the broad array, the ability of the employment appeal tribunals and the employment tribunals to deal with the factual complexity over 18 years before the Mencap decision. Thus, the cases I shall show note that where a person's presence at a place is part of their work, the hours spent there, irrespective of the level of activity, are classed as time work. Difficult cases may arise where a worker obliged to be present at a particular place. That presence may amount to their working. Conversely, it may not. An example of the latter is typically where a requirement is imposed on an employee to live at or near a particular place, but it's not necessary for that employee to spend designated hours there for the better performance of the contractual duties. This is unlikely to be time work. Presence facilitates work, but it's not itself work. Conversely, where specific hours at a particular place are required, on the pain of discipline if they're not spent at that place, and the worker is at the disposal of the employer during that period, it will normally constitute time work. And then finally in Whittleston, if I can ask you please to turn forwards to page 299. And here, as in fact with this is in many ways the decisions of the 4 presidents. One has Mr. Justice Elias as he was then, Lord Justice Underhill, Lord Justice Simler, or Mrs. Justice Simler as she was then, and Mr. Justice Langstaff. It's a clash in a way of the most distinguished employment jurists in England and Wales.
Beg your pardon, was Lord Justice Underhill, he was a president?
Yes. Yeah. Sorry.
No, I just wanted to be sure in my own mind.
No, absolutely, he was, yes. At paragraph 57, work is to be determined on a realistic appraisal of the circumstances in the light of the contract and the context within which it is made. It could almost be a quotation from one of your lordships, I think my Lord Kitchen earlier, as to when Mr. Jones is making his submission. In the circumstances of this particular case, there could, in my view, have been no answer other than it was work, and this being a time contract was time work. That is because the evidence was that there had been agreement between the employer and the claimant that she would work. She would have been disciplined if she had not been present throughout the period of time. She could not, for instance, slip out for a late-night movie or for fish and chips. The fact that her physical services were not called on during the night were, on the basis I have expressed, irrelevant, since her job was to be there. And that, we say, is the first requirement of the Trinity, that is presence. And if one wants to see a case on the other side of the line, one only needs to turn over the tab at tab 23 and see the case of Ray. And in Ray was a pub manager who at page 306, just below E, had to reside and sleep on the premises except on those occasions when the consent of the area manager had been obtained to his or her absence. And Mr. Justice Underhill, as he was then, analysed this in paragraph 13 at page 307. And this is the third line. In our view, it's evident that the requirement that the claimant sleep on the premises did not require her to do any work during that period. She was not in a position analogous to that of a night watchman or a night sleeper in a residential care home who has a responsibility throughout the night for those persons in the home, or to that of the hotel manager considered at Anderson, though she was not strictly speaking a national minimum wage claim. She had no responsibilities of any kind, and that is distinct to that of Mr. Shannon. So there are cases that fall on both sides of the line, and Ray and Whittleston shows you a dividing line. Second, Mr. Shannon was required to be present. Now, if I can take your lordships and your ladyship briefly, please, to the core volume of Shannon and page 709. And paragraph 11 of the tribunal's findings, 709.
Give me the page number again, please.
Page 709, my lord, in the Shannon bundle.
Yes, thank you.
In practice, the claimant was very rarely asked to assist the night care worker so that his nights were undisturbed. On the rare occasions that he was called out, it was usually to help the night care worker lift a resident who had fallen. On a very few occasions, it was Mrs. Shannon and not the claimant who assisted the night care worker when help was requested. And my lady, what's important here is the requirement to respond, which the tribunal has found contractually to exist at paragraph 10, in no different to the BNA nurse who's required to pick up the phone, Scottbridge, the person who's required to answer alarms on the telephone. Which brings me to my third part of this trinity, which is the regulatory obligation to be present. And still staying, please, with the judgment of the tribunal and going to paragraph 8, registered homes are currently regulated and inspected by the CQC. The Commission does not prescribe a specific ratio of care staff to residents. It's the care home provider's responsibility to ensure that staffing levels are appropriate in order to meet the needs of the service users. And this home was inspected by the CQC. Now, we set out at our case, page 609, please don't go to it, page 609, para 60, we set out the obligations, the regulatory obligations, and it doesn't go higher than adequate or appropriate numbers. But in this case, you can see what Mr. Shannon was occasionally asked to help with. That was to lift a faller. So in order for there to be an appropriate number of staff, it couldn't be the night care worker himself, there needed to be someone to assist him. We say simply that the reason why the regulatory obligation is important, and it was decided important in Esperon, is that normally a worker's work is to discharge an obligation of their employer. If I work in your cafe, my lord, and I serve coffee, it's because someone has paid your company or you to provide the coffee, and I'm discharging that contractual obligation. In this case, in the case of social care workers, the reason why Mr. Shannon had to be restricted to the house, the reason why he was required to respond was to discharge the regulatory obligation on the Rampersads. Why is that work? Shortly, because it's economic value. Because without it, a care home can't work 24 hours a day. Just backing off. The reason why that's work is it's the provision of economic value.
But there's nothing to say that it has to be a worker who's physically at work as opposed to one who's on call.
In this case,
you could say adequate staffing is provided by one night care worker plus another one on call.
It depends where that call was. My lady, we'd say if one looks, if someone falls down in distress, they can't be at their home 10 minutes away and waiting for that. We say they, and the facts of this case is that he was on the flat on top of the care home.
Well, the first limb of your trinity, as you've described it, is that you have to be present. You have to be present. Second limb, you have to respond. And the third is the regulatory structure.
Yes, my lord, yes. One has to be present at a restricted location.
Yeah.
And it's that restriction of personal autonomy included to the requirement of responding and the provision of economic value. Mm-hmm. My lords, my submission is that the proper construction of these regulations should determine the appeal. Secondly, one must consider regulations 15 and 16 before one secondly, one should consider the question of work before one considers regulation 15 and 16. Because if one fails to do that, one risks real injustice and one doesn't follow the appropriate tests under the legislation. We say that if one goes to page 723 of the core volume, page 723, paragraph 91, we say the tribunal erred, because when they looked at the question, the first question is whether the claimant was working throughout his shift. In our view, it's very important to note that the claimant was not the frontline worker on duty at night. That was the responsibility of the night care worker on duty in the home, who's required to be available throughout the night to attend residents. The claimant's role was to provide practical support to the care worker when called upon to do so. In practice, this was a very rare occurrence. Paragraph 91, we say, is an error because where Mr. Shannon was required to be present, required to respond, and providing the economic value of discharging the regulatory obligations, he was in fact working. And for those reasons, my lords, my lady, we say you should allow this appeal.
Thank you very much. Ms. Lord? Right, Mr. Reid.
Thank you, my lords, my lady. There's no doubt that the National Minimum Wage Act was a substantial piece of legislation of historic importance. And equally, there's no doubt that it was directed towards addressing the iniquity of the exploitation of the low paid. Nothing about our resistance to this appeal in any way seeks to question that mischief or the underlying philosophy of the legislation. But what is apparent from the legislation itself, and is important for the purposes of the construction that we recognise, is that Parliament didn't just choose to legislate immediately to define a national minimum wage. The structure of the Act contemplated that there would be an hourly rate of pay. But Parliament recognised that there was within that a difficult balance to be struck about the impact of a fixed national minimum wage on economic and social implications for the whole community, and the implications for business, the economy, and indeed the exchequer. So the solution to obtain a broad view of the impact was to, within the Act itself, contemplate the creation and use of the Low Pay Commission. And the Low Pay Commission is important because it reflects what was effectively an exercise in social participation between competing interest groups. We'll see when we look at it a little closer that it reflected interests both in relation to employers and interests in relation to trades unions, all to bring together a view, and in the end, a unified view as to the way forward. And that way forward was trying to identify, again, as charged by the legislation, two things. How one determined a rate of pay, a minimum rate of pay per hour, and this is important when we look at the way the structure of the legislation works, what would be the hours for which that would have to be paid? When we come to it, conceptions about work slightly direct you away from the true question, which is what are the hours with which one is specifically concerned for the determination of the rate of pay. And in that exercise, and this of course is fundamental to the interpretation, when one looks at the recommendations of the Low Pay Commission, it's clear that balancing all the economic consequences of what they propose to set to be the national minimum wage, a particular set of circumstances for some workers required special treatment, not because of who they were, but because of the particular circumstances of their work at particular times. And that reflected the fact that the view was that for those who slept in, who were required to sleep on their work premises, they would only be charged with working hours which had to be paid at the rate of the national minimum wage for the hours when they were awake for the purposes of working. And that was a clear objective underlying the recommendations, which the government accepts and seeks through the regulations to implement. Now, we're going to come back and look, of course, in the detail in relation to that, but it's important to see in context the balancing of those features. And that's reflected in part, and you'll not hear from her, but I commend to you the intervener's written submissions on the part of Ms Redston on behalf of the Local Government Commission, who particularly focuses on 2 points, which we, of course, echo. One is the cost, because we are exercised with construction, but it's a construction that has significant economic cost in terms of particularly the care sector, but in any sector where people are paid an allowance for sleeping in. And secondly, a point I'll come back to, clarity, because one of the things that is charged on the part of the Low Pay Commission in its recommendations was to achieve a degree of clarity, which one hoped for in the regulations, so that people would know when they were obliged to pay the national minimum wage and not obliged to pay the national minimum wage. Not least because, quite aside from the fact that it creates an enforceable common law right, enforceable back over 6 years, it also carries with it significant penalties which can be imposed by the HMRC for failure to pay the national minimum wage. They're now up to 200% of the underpayments under the most recent form of the regulations. And in the most egregious circumstances, and I acknowledge it requires willful breach, it also engages criminal sanction. So we're in a field where clarity is important in a number of levels. Our submissions effectively fall to answer 3 questions. The first is, we say that as a simple matter of the construction of the 2015 regulations, and indeed the previous 2 iterations, the original 99 regulations and the amendment regulations which we've seen take effect in 2000, as an exercise of construction giving effect to the whole, the relevant section in 2015 regulations, section 32, informs and explains the intention underlying the regulations, which is that a worker who sleeps at their place of work in suitable facilities for sleeping is only entitled to the national minimum wage when they are awake for the purposes of working. And read as a whole, the regulations clearly contemplate that that will be the case. We say that's a question of construction on the regulations as they stand. Similarly, as Lord Justice Underhill in the Court of Appeal approached it, we then turn to a second question. We say, even if on the straightforward construction of the regulations that wasn't the answer, we have a purposeful requirement here to give effect to the recommendations of the Low Pay Commission, a requirement that's directed effectively by the statutory background that required Parliament to expressly indicate if it was departing from a recommendation, which it didn't. And so we know that Parliament's intention was to give effect to the recommendation I've identified. And that's an important interpretive feature of looking at how the regulations have to be read. So our second point is that purposeful interpretation as an answer. The third position effectively really just turns on my learned friend's position in relation to findings and fact, and in some way this is a challenge to the idea of findings of fact. Of course, there will always be an element of finding of fact. There'll be an element of a requirement to find that someone is a worker. There'll be a need to consider whether or not someone is provided with suitable sleeping facilities for the purpose of the particular test. It's not devoid of factual position. But the way the regulations are drafted is to draft a clear and discernible line about particular hours not counting for the purposes of the calculation of national minimum wage. Can I, before I go into the particular subparagraphs of my argument, can I begin again by addressing a couple of questions? Sorry, I'll begin by questions. In particular, my Lord Kitchen made the observation that work is not an overarching definition, but in the context is the important question. What is work in the context? And I make this observation that, and I alluded to it before, that actually the question underlying the regulations is not really the question of what is work, but what are hours of work? Because the way the legislation is constructed and reflected by the original way in which the Low Pay Commission was charged with its task, was to identify a rate of pay per hour and also to identify how those hours of work would be defined. So actually, the real question is something to be counted as an hour of work for the purposes of the national minimum wage? And we know that the approach is to take the straightforward one, that requirement, in the normal case, requirement of attendance at work, whether or not you're physically engaged in a particular activity, is sufficient to count as an hour of work for the purposes of the national minimum wage, which is why there is a very clear and straightforward answer to my Lord Wilson's question, and one why my learned friend struggled to have an answer to it. The question, as I understood it, was, if your employer requires you, as part of the service it provides, to be on the premises, in what sense are you not working? Well, the answer to that is you are, except that the Low Pay Commission's view was you would not be, for the purposes of national minimum wage, entitled to be paid at that rate for those hours when you were provided with suitable sleeping accommodation and were not awake for the purposes of working. That is the clear and straightforward line that the regulations define.
So you're at work, but you're not earning. Is that it?
Well, you will be earning in the sense as an allowance, but you are not entitled to the national minimum wage for that specific period of time. You are at work in the sense of being present at work, but you are not engaged in a working hour for the purposes of the national minimum wage.
You're at work, but you're not working.
Yes. In fact, what you are, and it fits with common sense, with the intention, is you are in fact asleep. You are asleep, and only at the points at which you are awake for the purposes of working will you be working for the purposes of the legislation.
If you're available for work.
If you're available to work. Can I, just for those purposes, because there's a certain degree of uncertainty about the precise position, just be clear as to the circumstances that specifically applied in this case? And I appreciate we're looking at a broader picture in the regulations, but I want to be clear as to the structure, because we say it reflects something which was typical of the way that care provision operates. If you turn to the core bundle within the Tomlinson-Blake appeal and the case for the respondent, and that is in MS page 509 is the relevant passage.
Can you give me a paragraph?
I'm going to take, actually it's 508, I do apologise. Paragraph 5 is the beginning of this section. This simply outlines the factual findings and the structure of the claimant's employment relationship. And again, one of the complexities of the legislation, I'll come back to it, is that it does expressly adopt a sequential approach in looking at the particular categorisation of whether someone's engaged in salary work, time work, output work, or on-measured time. It actually tells us if A, then A. If not A, is it B? And that's expressly built into the legislation. And it may be, as indeed is the case here, that someone might be engaged in different types of work at different times. So in the particular case of the appellant, she was salaried and had regular work shift hour patterns. If I remember properly, she had a regular 37.5-hour week, and her regular work shift hour patterns were, as paragraph 5 set out, either a daily shift from 10 till 10 or 3 till 10, or an early morning shift, 7 till 10 or 7 a.m. to 4 p.m. That was part of her salaried work. There's no issue with that. On top of that, there was an occasional obligation to perform a sleep-in between 10 p.m. and 7 a.m. the following morning, in respect of which an allowance was paid of £22.35, and Mencap's approach was to pay 1 hour's pay at national minimum wage on top of the allowance, and then to pay further than the 1 hour if it was the case that the worker was called upon to carry out any duties in the night beyond that 1 hour requirement. And if you turn to paragraph 7 and the subparagraphs which begin at 509, the appellant was provided with her own bedroom on site, and it was positively expected that she would sleep. That was the expectation, because typically it was going to be between two normal shift patterns. No tasks were allocated during the night shift, and it's true that there was a requirement for her to be there, and if she was awakened, to call and deal with any situation that required her attendance. That's the need which was present.
How was that measured? I mean, if she was called upon to help for, say, 10 minutes, did she get a full hour's national minimum wage?
Mencap paid an hour on top of the allowance.
I appreciate that. But that was a regular payment. That
for every shift, every sleep-in was paid for the hour.
That wasn't occasioned by her being called upon to do something. If she would, but as I've understood your submission, if during the night she was called upon to render some service, an extra payment was made.
If it took more than the hour, yes.
If it took more than the hour.
Yes. So imagine there was an emergency that required her to deal with those who were recipients of care at the premises, and that took her 3 hours of her time. Then the expectation and the agreement was she would be paid at the appropriate rate for that time.
Well, for 2 hours above the hours that she was getting.
Yes,
anyway.
yes.
I see.
And the expectation was that this would be something that was going to happen infrequently, and indeed that was the reality. As noted at little c, the evidence before the tribunal was that there had been approximately 6 occasions in the 16 months prior to the tribunal hearing when she'd been disturbed and had to perform an assessment or actual task.
Keeping a listening ear while asleep presumably meant somebody had to wake her up.
Yes, or she had to be woken up.
Yeah, someone had to
be
woken up by some sort of activity or event, or
either someone knocking on the door, wanting her assistance, or by some event which woke her from her sleep. Lord Justice Underhill describes that phrase as being metaphorically sleeping with a waking ear. It's obviously the case that anyone who's sleeping in for a purpose, because no one simply requires a worker to sleep on the premises without there being a purpose, there would be no objective to it, is doing so with the prospect that they might be woken. But we're concerned here with the distinction between those periods of time when they are actually asleep and when they are awake for the purposes of working.
There's no suggestion that she slept less well because she knew that she might be woken up.
I don't think there is on the findings. We'll come and see that one of the arguments that after the first report and the second report of the Low Pay Commission, the trades unions seek to persuade the Low Pay Commission to revise this recommendation and to introduce not the national minimum wage but some fixed allowance or at least a higher rate of pay, because their submission was that people didn't sleep as well in circumstances where they're on call. And that's not a recommendation that the Low Pay Commission acts upon, as we'll see. They remain...
There seem to be all sorts of gradations, because obviously if you're a doctor working at night in a hospital, you grab what sleep you may, but you're expecting you may have to get up quite regularly. So, I mean, of course, I imagine unless you're very good at sleeping, it'll probably affect it. But here, as I understand it, the expectation was she wouldn't be woken up. Indeed, the number of times was very few indeed. So, obviously, if your likelihood, at least my likelihood of sleeping, would be very much affected by the extent to which I thought I was going to be woken up by something.
Yes, well, and that, it's absolutely clear the expectation that she wouldn't be, and that was part of the assessment that's taken in relation to the care. We deal with it at paragraph 8, just over the page at 510, because the position of Mencap is that in circumstances where the needs of the clients required them to have a higher level of intervention, then the approach was to arrange for what's called a waking worker to be available, because that will be a waking night in the expectation that that person would be called on more regularly. And not surprisingly, just stepping back, that's obviously costed in an entirely different way, and the resourcing that the local authorities have to provide is entirely different, because it reflects a level of care support at a higher level. So part of the exercise here was to form a view of the needs of the clients, and that reflected the fact that the view was that during the night period, encouraging them to independent living, what was needed was a presence, but not an active element of care, reflected by the facts.
I mean, these are all said to be findings of fact, but presumably an organisation like Mencap would have worked all these out with a view to the regulations, obviously, and there would be some sort of protocol or something governing the way they dealt with these.
Well, the recognition was that if the needs changed because the demands of the clients required a particular occasion, then the care plan would have to be revisited to look at someone's needs. Can I say, and we'll come back to this, that the context of all of this, there is the regulations, there is the recommendation, and although of less statutory, of no statutory import for the purposes of interpretation, we'll come and see that the guidance that was being given, certainly in 2008, after these some of the initial cases which we've looked at, such as British Nursing, Scottbridge and Walton, was perfectly clear that someone who was sleeping on the premises in suitable accommodation was not working for the purposes of national minimum wage, except when they are awake. I'll take you to the guidance to make it clear. What happens is that there are, and we would say it's a path that's gone down erroneously from the Court of Appeal decisions, in part because they weren't taken to the Low Pay Commission. No criticism apart from a passing reference in Walton to the Low Pay Commission recommendations. There's a path which unfortunately leads to the EAT creating a complexity which simply isn't there in the regulations. And that ends up with concerns and eventually a change in guidance in 2015 with the deep concern for those instructing me in the industry that suddenly it now appeared that there were circumstances in which people had to have a liability to pay the national minimum wage for the whole of a sleep-in. And that's where Miss Redstone's reference to historic liability and an increase in cost comes from, because suddenly one might have the potential for a liability going back 6 years against a background when one understood that the arrangement was in accordance with the recommendations which had been made initially and in subsequent guidance.
But then we get the 2015 report of the Commission, which seems to sort of almost adopt the existing EAT case law and doesn't seem to suggest that there's something wrong with it.
Well, can I?
I mean, come to that in due course.
I'm happy to deal with it now.
One of the worries I picked up is we have that, what everyone thinks about the pre-existing case law, the EAT, the Commission seemed to more or less take it on board.
Can I say two things about that, and I'll come back and develop it more clearly. The first is, and I'm sure it was partly through being truncated in time at the point, because obviously that's the way it works, that my learned friend left you with a slight impression that the 2015 regulations were the product in some way of that Low Pay Commission.
No, I think he made it clear, and in fact I've looked at them, they're quite clearly consolidation, and they go out of their way to say this is not changing, making a substantive change.
No, I think they talk
So
about
I think that is clear.
Yes, and when one looks at the Low Pay Commission report, I'll take you back to it later, in 2015, what they recount is the government's evidence, and at the end of it, they don't make a recommendation. When you actually look at the report, the recommendations are distinct and separate. They merely make the observation that greater clarity is required in relation to the guidance. Now, that leaves us with the uncertainty of whether or not they thought that their own earlier recommendation, and of course by now, you know, water has passed under the bid and the composition of the Low Pay Commission has changed, but it leaves us with the uncertainty of where they stood. What we do know, though, is that what the statute requires is the recommendations to be considered and to be given effect to. And when one looks at the recommendation is clearly that which Mr. Jones recognises back in the original first report. And we never see an occasion when there is any change in that recommendation. In fact, quite the reverse. When one looks at the subsequent reports, and I'll take you through them, there is a reinforcement of that particular recommendation. So, if I can put it colloquialism, it's almost like trying to pull yourself up by your own braces, to rely on the errors which we would say slip in through the Court of Appeal, not seeing the recommendations, leading to a chain of events that leads the EAT to have a succession of decisions about it, the government then giving evidence based upon those particular decisions. But actually, what hasn't been recognised is that the interpretive exercise really ought to reflect something which is much clearer and something which is much more certain. And we say that's the position. If Parliament wishes to change it going forward, now 20 years on, with a view on the economy and the market, no doubt it can seek the Low Pays Commission in relation to whether or not there should be such a change going forward. But we say for the past, and more importantly to this point now, the position is absolutely clear. I indicated that I was going to take you to the Low Pay Commissions and some of the later versions. Can I, however, just to begin with, take you back to the first report, and that was in Appendix 2A, and the relevant MS page is 761.
As you know, we haven't got those pages. Which paragraph of the report?
Oh, I do apologise.
Which paragraph?
I'm sorry, do apologise. It's my fault. Sorry? 211.
Page 211.
Yep.
It's the beginning of the report.
Apologies a second. It's my page. Just the first.
Yes, the report begins at page 211 to 12, which is the paragraph you're looking at.
Thank you, yes. I wonder if I may go to, apologies. I want to go to the introduction to the report. Section.
The forward, page 221,
Chapter 1 is the introduction.
the executive summary on page
236 has the
Ross, would you like to borrow mine, Mr. Reid?
No, I do apologise. Thank you very much. I'm sorry, it's the executive summary.
Executive summary.
225 on the inside spine, I do apologise, it's because 225 on the, so the executive summary, actually if I apologise, might go back a page to 221, this is just to make good my observation about the objective, so I apologise for that. You find the foreword from the chairman of the Low Pay Commission, Professor George Bain, and these are words which echoed my opening words, of course, where I drew them from. sets out the background of the Commission's objective at paragraph 1. And as I noted, the second paragraph observes that this was an exercise in social partnership, the objective of which was to draw across the wide basis of employer, employees and academic backgrounds, and there was a significant academic economics background in relation to matters. And the third paragraph I particularly note is that they were concerned to look at various aspects and the implications for wide varieties of workers. But I note in the sixth line down, our terms of reference rightly emphasise the importance of understanding the economic and social implications of our recommendations. Our recommendations are also made against a background of emerging policy and related government initiatives. We're determined that the national minimum wage should be complement and underpin government-wider welfare to work policies, including its individual initiatives. And if I just turn over the page, at paragraph 5, they note the objective of addressing the worst cases of exploitation, but paragraph 6 records the fact that they're determined to make recommendations which business could afford. No one wants a wage that cannot be paid, and we're struck by the extent to which businesses are welcome the general principle of the national minimum wage. So thus they're reflecting the balance that had to be struck in relation to that exercise. And one can see that that involved them, and I apologise that the executive summary is the next place I just briefly wanted to go, which is at page 225, paragraph 3. It's evident that in the exercise involved them taking an extensive consultation exercise, and that embraced a wide number of employers and employee representative groups in order to get that broader picture. And that, of course, is the context in which we say the recommendations were made. Now, my learned friend took you to the recommendations themselves, and he took you thereafter to the underlying philosophy beneath the particular recommendation with which we're concerned, which is recommendation 12. You recollect that was that's at page 234, and it's the recommendation that for hours when workers are paid to sleep on the work premises, workers and employers shall agree their allowances as they do now, but workers should be entitled to the national minimum wage for all times when they are at work and required to be available for work. And then we're referred to paragraph 434. Now, my learned friend took you to 434, but it's important just to see the section that that was part of, which begins at page 281.
Can you give it the electronic number as well, please?
831.
Thank you very much.
This was under a section called working time. And it noted that at paragraph 4.31, as I explained, one of the things they needed to do was to establish what would constitute working time for the purposes of the national minimum wage. So it's directing at looking at defining hours. And stepping back, my learned friend has explained it, in the way the legislation works, essentially, is to define how you establish the hours and then define the amount of pay that someone has received in relation to a particular pay period for those hours, divide one by the other, and if they are not being paid at the national minimum wage, there's a breach. So determining the hours is a critical exercise. They look at a number of other sources of legislation, which at some point in some of the cases have clouded the vision a little bit. But actually at 4.32, they say this: the important distinction for our purposes is between time at work and time for which the worker is paid. The latter can include paid absences from work, such as holidays, sickness absence, layoff periods, which are covered by other legislation. The definition should take into account that workers who do not have any contractual hours of work, for example, called 0 hours contracts, and employees who are paid entirely according to their output. So what they focus on, therefore, is that the actual working time definition should define what constitutes working time. So it's focusing on what those hours would be, but making it clear at 4.34 that in doing that, they are not recommending that hours which constitute sleeping arrangements are included in those hours. So my learned friend says that this is a sequential exercise even in the recommendations. It's simply not. They're looking at trying to work out a definition of hours, and the definition of hours ignores the performance of duties, but focuses about being available or present, but recognises an issue, which one can define as an economic issue, for those who are present but actually asleep, and therefore defines it in a way, or seeks to define it in a way to say, well, actually our recommendation is, although we've regarded people who are simply present as having hours of work, that won't be the case in circumstances where they are able to sleep, and there there'll only be hours of work if they're available for the purposes of work. Now that recommendation is clear, and we say was clearly implemented by the regulations. My learned friend mentioned that what subsequently happened is that there have been low-pay commission reports on an annual basis, primarily for the purpose of looking at whether or not the rate of the national minimum wage needs to be changed. And the second low-pay commission report occurred in February 2000, and that is in the Respondents' additional documents. Tab 1, and in that, can I take you to the recommendations which were made on that report, which are 1,861 on the MS page numbering.
1861.
1861.
Thank you.
And it's page 16 within the physical copy of the report. The recommendations aren't numbered, but the relevant recommendation is at the bottom of the page. And the recommendation is the government should produce specific guidance to emphasise the difference between sleepovers, where the assumption must be that the worker would not normally be wakened, and where an allowance is usually paid, and on-call and standby arrangements where a worker is required to be at the workplace outside of normal hours with the expectation that he or she will be required to work for which the national minimum wage is payable. And that reflected the fact that there had been submissions to the Low-Pay Commission to reconsider in part its previous recommendation, and you find that at MS page 1941. It's paragraph 5.38 in the report and page 96 in the actual report itself. And there had been evidence from the TUC that workers who do sleepovers were the most vulnerable, having had their terms and conditions worsened as a result of the national minimum wage. And they set out a case that those workers have been taken advantage of by reason of the regulations. And a point is made in terms of their evidence about the quality of sleep. And at 5.39, the TUC's evidence was to suggest that the regulations are altered so that workers are fairly compensated for sleepovers, either by recalling an on-call allowance for such periods or requiring sleeping time to be paid at a percentage of the national minimum wage. I just pause to note there, it didn't seem to be suggested because it was absolutely clear that the previous recommendation was that workers would not be being paid the national minimum wage for their sleeping time. The TUC's evidence was to adopt a slightly more middle ground, to say, well, you've got nothing to deal with the allowances and stipulating them, so a fair approach would be to require what those allowances might be, or create some reduced or partial national minimum wage rate. The recommendation you find over the page at 5.41, and having considered that, the Low Pay Commission's recommendation is based on the fact that it isn't their role to determine pay allowances or supplements, which employers agree with the employees, but we are concerned whether there's scope for employer abuse of sleepover practice. And that's where the recommendation comes for guidance, but noting, as I have already, that the focus is upon that guidance making it clear that workers who would normally not be wakened, and the assumption is that they are sleeping, is a set of circumstances in which they are not entitled to the national minimum wage.
So what happens then?
Specifically, there is no specific guidance at that point. I'll take you to some guidance in 2008, but nothing directly happens. There's no change to the regulations. Well, there is a change to the regulations we know in 2000.
So they don't bite on this?
No.
Okay.
And this isn't a topic that's returned to until the fourth report of the Low Pay Commission, which is in March 2003. And you find that in Appendix 2B, and it's 1091 in the digital version. And
Sorry, what's the other number?
I'm sorry?
What's the
it's
other number?
542, I'm sorry.
Thank you.
So this is the fourth report of the Low Pay Commission. And in the fourth report of the Low Pay Commission, they return to this topic, and that is at page, internal hard copies, page 664, and digital 1214. It's passage beginning at 3.55 at the top of the page. I just pause to note that one point of interest is that this is after the decision in British Nursing, after the decision in Walton, and after the decision in Scottbridge, because those were all slightly earlier in time. But at 3.55, they look at the economic impact of national minimum wage in the care sector, and they look at the particular policy question related to how it should apply the national minimum wage to sleepovers. And they give an example, exactly the example of someone who works in a day shift in a care home and then sleeps overnight and is available to deal with emergencies, but would not necessarily expect to be woken. Although not a care home, we would say our factual scenario. And then at 3.56, they say, in our earlier reports, we concluded that sleepovers, where the assumption is the worker will not be woken, the national minimum wage should not apply. In practice, an allowance is usually paid, but workers should be entitled to the national minimum wage for the times when they're awake and required to be available for work. We noted the differences between these sleepovers and on-call and standby arrangements where a worker is required to be at the workplace outside of normal working hours with the expectation that he or she will be required to work for which the national minimum wage is payable. The government accepted and acted on our recommendations. We believe that these still reflect the right approach. The recommendations they're referring to there are the original recommendations and recommendation 12. So having considered it, the Low Pay Commission is remaining of the view that the national minimum wage should not be paid in scenarios of the sleepover that's just been described. And once again, if you look over the page at 3.59, what they say is, by way of recommendation, is because there has been some uncertainty, that the government should consider whether it's best resolved through guidance or whether a change to the regulations is required. They're only contemplating a change to ensure that the regulations accurately reflect their own recommendation, which they remain consistent with.
But there's no reference here to Scottbridge or...
No, none at all. There's no evidential, I've not seen anything to suggest that that was being portrayed, other than that there appears to have been some judgments. If you look at 3.57, they don't directly refer to Scottbridge, but what they do say is certain recent employment appeal tribunal judgments have held that the national minimum wage was payable in circumstances where the worker was able to sleep at times during the night. Some respondents to our consultation expressed concern that these judgments might imply that the national minimum wage was payable in a sleepover case, which we considered earlier. There was a concern.
So can we infer which the recent EAT decisions were at that point?
We tracked the timescales, and at that point, as I say, there'd been the Court of Appeal cases. At the time of that particular decision, the particular report, I think none of the ones which we have before you include direct decisions, other than that there had been tribunal decisions underlying the British nursing case.
Yeah, well, never mind, then it doesn't matter.
And there's also been a tribunal decision underlying the Walton and Independent Living case, because they were appeals from tribunal decisions. But my primary observation is to make that there had been uncertainty, but the approach of the Low Pay Commission is to say, no, our recommendation was our recommendation, we remain with our recommendation. If there's a problem here, it's about the clarity of ensuring that our recommendation is not being followed. So there was a view as to how the government might deal with that. They didn't deal with it in the sense of any amendment to the regulations by way of clarification in any respect, as we'll see later on, that all that ever happens with the regulations is we say that there is effectively a consolidation in 2015, and there had been the earlier amendment relevant to this in 2000, but no change.
Nothing more recent from the Commission than 2008.
There is, we have the one that my learned friend mentioned,
yes.
The 16th report in 2015.
We're going to go and have a look at that again.
We'll go and have a look at that. But that's a report where we say they don't make a positive recommendation.
Quite, yeah.
I'm not aware, and I'm sure I would be, if there had been a recommendation that arose out of more recent events. Obviously, most recently, recent events have really focused on the courts, because this litigation has been trundling on for a while now, and it reflects the fact that there's one might say, some uncertainty to see where the law stands in relation to matters.
How would Mencap have been a consultee for the Commission, do we know?
I believe that they have, I believe they did give evidence.
I mean, I imagine they would, all bodies like...
I can't be certain about it, but I'm pretty certain they did. Yeah. And there undoubtedly has been concern about uncertainty and ambiguity in relation to matters.
Just before you leave this, the Commission appears to be drawing a distinction between cases where there is an expectation that the person will have to work overnight and those cases where there is no such expectation.
Yes, and they contrast that expectation with a situation where the expectation is that the person will be able to sleep.
Yes.
It's right to say that that precise distinction doesn't appear in the wording of the regulations. They've never contemplated a position of judging the position of the expectation of the degree to which one will be sleeping or not. They draw, and I would respectively say sensibly so, a clearer line by saying, if you are required to be there and suitable facilities are available, then sleeping hours are not national minimum wage hours. That avoids the difficulty of trying to ascertain gradients between the degree to which someone's actually called upon.
So even if one might expect to be called upon 6 times a night, that would still not count as work, save for those occasions when one
I have to say, I have to acknowledge that as I read the regulations, that must be right, because the regulations are framed around the concept that that time doesn't count, assuming that the individual is provided with suitable sleeping facilities. The phrase is by arrangement they are provided with those. Then the wording of the legislation means that it's only when they're awake for the purposes of working that they would be entitled to it. Obviously, if they are awake a great deal during the night, then the prospect is that there will be significantly more time when they will be paid at the national minimum wage rate. But I can't hide away from the consequence that the position is there is clarity.
Yeah.
It's a clarity that draws a bright line, and our position has always been that the bright line is an important one for a number of reasons in relation to the legislation. Can I just finally, before I close for today, just take you, because you asked about guidance, and it's important just to look at what guidance there was. Certainly during the relevant time that we're concerned with here. I'm in Appendix Part 2B, and I'm at page 850 in the hard copy and 1,400 in the digital page. This is the Burr guidance from September 2008 on the national minimum wage. And so we are after the recommendation for further guidance or defined regulations. And we say that this is perfectly plain in terms of guidance, consistent with our interpretation. You find it at the bottom of page 850. Sleeping between duties. If a worker arranges with his employer to sleep at or near a place of work and he's provided with suitable facilities for doing so, the time when he's permitted to sleep is not working and is not working will not be treated as time when the national minimum wage is payable. And if he has to get up and do some work during the night, the time spent awake and working will count as time when the national minimum wage is payable.
Is this guidance that is produced pursuant to some requirement of a statutory instrument or not?
I'm not sure of the answer to that. I'm not sure there is a statutory obligation to produce guidance on the point under the Act. I'll check overnight.
Is this still the Low Pay Commission making the recommendation?
No, this is not the Low Pay Commission. This is guidance from the Department for Business, Enterprise and Regulatory Reform as to how the regulations are intended to operate. And I should take you over the page to 851. It notes that a number of employment tribunal cases have touched on the issue. Provided the employment contract clearly sets out the period when the worker is permitted to sleep and the employer provides suitable sleeping facilities, the worker need not be paid the national minimum wage in respect of that period if he's not actually working. He must, however, be paid the national minimum wage in respect of any time during the period when he's awake for the purpose of working. In cases where the employment contract does not clearly specify any sleeping time, the tribunal seemed likely to conclude that the national minimum wage should be paid for the full time when the worker is at work. However, the case law in this area, in the area of sleeping time for the purpose of working time regulations, is still evolving. Employers are unsure how the law may apply to arrangements they may have made in respect to particular workers may wish to seek independent legal advice. Not always the most encouraging bit of guidance if you're worried about whether or not you've got a substantial contractual liability or maybe at risk of a substantial fine from HMRC. But at least I say consistent entirely with the way that the regulations were drafted.
Is the example of help, the sleeping time example?
The example, yes, and the example is we say consistent with the approach that Mencap took, and indeed takes in relation to the construction of the regulations.
Yeah.
Because the sleeping period between 11:30 and 4:30 in the morning is not required to be national minimum wage unless the individual worker is required to be awake for the purposes of working. I was going to move to...
Well, it's 4 o'clock, we'll rise now. And we'll sit tomorrow at 10:30 or as soon thereafter as we can, because there's a certain event involving the swearing in of the Deputy President of the Court tomorrow, which may delay us, but only very slightly. Yeah. Right. Court's now adjourned.